Supreme Moot Court of Victoria, Court of Appeals Division, in a matter of balls on campus, the appellant and Karantzis Liable, the respondent, an issue of apportionment of damages before Justices Karantzis, Tartaglia and Carbone. The appellants.
May it please the Court, my name is Tony Carbone and I appear as Senior Counsel for the Appellant. My learned colleague, Blake Connell, will appear as my junior. Our speaking time today will be divided 14 minutes to myself, 13 minutes to my co-counsel, reserving 3 minutes for rebuttal.
If it please the Court, Paul Milliken appearing on behalf of the Respondent, Karantzis Global. I appear with my learned co-counsel, Jacqueline Hope. To the allocation of time, I shall speak for 15 minutes, and Ms. Hope will speak for 15 minutes also. Please, the Court.
May it please the Court, I begin my submission. Your Honors, the issues of liability and apportionment are live in this case. And because of how inextricably linked they are, my co-counsel and myself will not be dividing the two between ourselves, but instead dealing with this matter in the typical structure of negligence. That is, firstly, what was the duty of care owed, the breach, and finally, the causal link between those breaches and the harm suffered. On this matter, Your Honors, I would like to quote briefly to the Court from the case of Padre Basek and Australian Iron and Steel, Proprietary Limited, 1985, 59 ALJR 492. And if I may, Your Honors, at this point I will dispense with formal citation. Thank you, Your Honors. I quote briefly from their Honors Justice Gibbs, Mason, Wilson, Brennan, and Dean at 494. The job before the Court today is one in which the Court is doing a balancing act, that is to say, a comparison both in culpability, that is, the departure from the standard of care of the reasonable man, and furthermore, of the relative importance of the acts of the parties in causing this damage. Your Honors, I emphasize these points because the language we will be using before the Court today is not that of existence of a duty of care or a breach, but in degrees, that is, holding comparison between Ballers and Karantzis and the particular duties owed by each. At this stage, Your Honors, I would like to acknowledge that, of course, appellate courts have showed a general unwillingness to rethink the apportionment at first instance. However, Your Honors, there are several cases that we cite today in which just that has taken place. Specifically, I draw the Court's attention to the case of Grima, which my co-counsel will speak to at length, in which the courts decided to reapportion significantly between the employer and the occupiers. On this matter, Your Honor, the Court simply needs to be satisfied that at first instance, the Court had not done what is just and equitable, as per Section 24(2) of the Wrongs Act. Your Honors, we submit that that is the case before us today, and that a more appropriate apportionment of the liability between the appellant and the respondent would not be 60-40, but instead 10% to the appellant, Ballers, and 90% to the respondent, Karantzis Global. On that matter, Your Honors, we have 3 simple submissions before the Court, the first of which I will speak to. I draw the Court's attention to that submission at this stage now, being a comparison of the relationships in question. At our first submission, we would like to put forward to the Court that there was a non-delegable occupier's duty owed by Karantzis Global on this matter. This was a more onerous duty than the transient one that existed for Ballers on campus. Your Honors, I emphasize this point importantly at this matter because even if the Court is to determine that the breaches were of the same magnitude between the two parties, if a more stringent duty of care was owed by one party, the Court must have a mind to that in regard to those breaches.
Counsel, why is the occupier's duty non-delegable?
In regards to occupier's liability being
Yes.
non-delegable. Your Honor, we have several submissions on that part. So if occupier's liability is accepted, it's one that is well established in both case law and, of course, by statute. Specifically that, of course, there are some duties which can be delegated to independent contractors, but in this case, the particular duty of looking after the wall was not delegated. I draw the Court's attention to our submission at 1.3 on this matter. Specifically, that Justice Carlson's assertion that, in a sense, that had been delegated, mischaracterizes what Ballers was employed to do. And I quote from the material facts, outlining, spraying, and the installment of 3 basketball hoops. With respect, Your Honors, there is a fundamental difference between wall maintenance and repair and that of basic installation.
Counsel, your client received payment for those services provided. Now, those services entailed the use of that wall. How do you get around your duties in this instance by ignoring the wall?
If I may,
how do you get around that?
If I may, Your Honor, I'd like to address that through the use of an analogy. And I draw the court's attention to the case of McVicker and S&J White. In that particular case, the court found that the occupiers did not owe a non-delegable duty because a cleaner had used an unsafe product which made the floor too slippery and a person had slipped. However, Your Honor, the court did consider in that case the difference between what is brought by an independent contractor and that which exists on the premises itself. Specifically, that if there had been a dent in the floor where cleaning fluid had pooled, that would have been damage to a problem with the state of the premises, and the occupier could have been liable, versus the cleaning fluid. That is on all fours with this case before us, Your Honors, because it is not alleged that the hoop was at fault, that it was a faulty product, or even that it was incorrectly installed. It was the wall itself, part of the state of the premises, which caused the damage in this case.
And you say that your client acted appropriately in its inspection of this wall?
Your Honor, we do not attempt to abrogate the fact that a breach was committed and that there was negligence on the behalf of ballers on campus. However, Your Honor, we hold this in comparison to other breaches. Specifically, and I'd like to draw attention to what is somewhat of a challenge in the timelines between our own case and that of our learned friends, that of what the JSA and the risk assessment could refer to. I draw the court's attention to the fact that when the JSA and the risk assessment were created, Christopher Wallace, as an advocate of ballers on campus, had awareness that he was installing 3 hoops. There's nothing on the material facts to suggest that he knew exactly where those hoops were going to go at that stage. That meant that at the stage he was assessing the wall, and that ballers had the opportunity to assess that wall and appreciate the risk of that wall. They did not yet know its connection to the hoop.
And his assessment, what do you think of his assessment?
Your Honor, we would submit that
He's
it was...
He's a representative of your client. What's his assessment here?
Has
he gone far enough?
Your Honor, we would assert that this was the breach that existed in this case, that there was some unsureness to the security of the wall, and at that stage, the employer should have gone further to investigate the stability of the wall. We do not attempt to get around that breach, Your Honor. However, we attempt to hold it in comparison to those of...
Has your client advised the employer of this? The occupier of this?
On the facts, Your Honor, no. It appears that this was an internal process,
That's
the JSA.
That's a pretty big omission, isn't it?
Your Honor, we would assert that, of course, that would contribute to the negligence on behalf of HATSIS. However, if I may speak to the material facts, there are several things that draw attention to their negligence on this matter. Specifically, the existence of the wall for 22 years. In this matter, it was not a wall that had been created and finished at that particular time. This was a work site that was left unfinished and lay dormant for 22 years. That in itself must be taken into consideration as something that was known specifically to the respondent. Furthermore, Your Honors...
Sorry, Counsel, what do you say to the fact that the respondent, I think it's John, wasn't aware of obviously the background around that? Shouldn't more questions have been asked from your client's end?
Your Honor, we do submit that further questions could have been asked to ascertain that. However, it is enough that either Counsels, we submit that actual knowledge did exist in this case, even if not from John Snow, then from delegates or representatives of HATSIS. If not, we submit that constructive knowledge is sufficient in this case, and particularly that John Snow was well positioned to have that constructive knowledge. I draw the court's attention to the material facts in regards to Stalker Space. Not only was Stalker Space making comments in regards to the dodginess of the wall, but John Snow is a person employed to look after online relations with students. That should draw his attention, particularly in this digital age where a company's reputation can be made or broken by comments made on these type of sites. It should suggest that Karantzis, and in particular this individual, had an awareness of those comments.
But those comments are only speculation, innuendo. There's nothing about the wall itself that would indicate that there was faults with the wall.
Nor formal complaints.
Yeah, and no formal complaints.
Your Honours, we have several submissions on that particular fact. Given that this is a school, it would be somewhat out of the ordinary for students to make formal complaints on a lot of matter. Social media is a place where students validly express their true feelings on particular things, including relations around the campus. Sorry, if you could repeat the question, Your Honour, I've strayed away from it at this moment.
Not only, but with the wall, it was there for 22 years, and after your client completed the works, that's when there was a problem with the wall. So is it possible, see, we can't get that from the facts, that it was the works performed by your client that made it unstable?
Your Honour, on that point, we submit that given it cannot be shown on the material facts, that at the very least, establishing that occupier's liability, as has been done in relation to duty of care, that there should have been more attention paid by Karantzis Global over those 22 years to the condition of that wall. Specifically because under occupier's liability, that is a duty they owed to everyone who came onto this campus and could come into contact with that wall.
But they had no knowledge of any problems with the wall until this incident occurred. There was nothing that you could discern from the wall by just looking at it that there was a problem on these facts.
On these facts, Your Honours, we agree with that, given that Christopher Wallace was unable to determine at that point in time. However, the fact that students had commented on this over the years on Stalker Space indicates to us as the appellant that perhaps at different points in time there were things to suggest that that wall was unsafe, things that were not apparent at the time that Christopher Wallace came. For example, bricks that had at different times fallen out and been put back into the wall, or just generally on the suggestion that students came into the contact with that wall over a longer period of time and were in a better position to perceive that danger.
But counsel, John Sow had only been there for 3 months, so may have no knowledge about that.
And he was the wrong person to ask.
Yeah.
Should have made further inquiries.
So what do you say to that effect? So
That he'd only been there for 3 months?
Yeah.
Your Honours, John Snow was put forward as the delegate to act as a liaison in this particular matter, that on several occasions he interacted with ballers on campus on this particular matter. If he was not the right person and was not supplied with the right information, that responsibility lies on Karantzis, that they should have provided a better delegate that could have warned of that risk to ballers on campus.
But equally, your client could have asked for a director to provide that information. Because from the facts of this case, John Snow's got no authority at all.
Your Honours, we do concede that point. Although I'd like to emphasize to the court that we hold that in comparison to several breaches that we'd like to put forward on behalf of Karantzis. Specifically, that they should have provided ballers with further information. Secondly, that they should have issued the no dunking rule as soon as or before the court became functional. And lastly, and most importantly, that they should have conducted those regular safety checks. The second point in regards to the no dunking rule, my co-counsel will speak to extensively at the stage of causation. But at this stage, we rely on the combinations of those breaches to emphasize the comparison in this case.
Counsel, you say that Karantzis should have provided you with more information, but your risk assessment, you didn't ask for more information. The alarm bell should have been ringing on the basis of what was provided.
So is your concession that your client should have made further investigations?
It is, Your Honour, that either through the realization of what was on the JSA and risk assessment, that they needed a better liaison, or alternatively, they could have asked further questions at that stage.
Then what's the impact upon that on the issue of liability then?
Your Honours, no single strand of our argument relies on the other, so that's one that stands alone, and that is where we do make the largest concession in regards to a breach. However, proceeding forward, Your Honours, and looking at the entire calculus of breach, we again draw attention to the reasonable foreseeability in this case. Actual knowledge on behalf of Karantzis versus the unsureness or need to ask further questions. on behalf of ballers. We hold that in regards to reasonable foreseeability, that should weigh in favor of ballers on campus. In relation to the calculus of negligence, I allow it to my co-counsel to speak further to that point. And with an eye to the time, I'd like to just briefly draw Your Honor's attention to our submission at 1.1 in regards to, and I apologize, my time has concluded. May I briefly have an extension to explain this submission? Thank you, Your Honors. In relation to the issue of independent frolic, I leave it to Your Honors if there are any particular questions on the issue of the relationship of employer-employee not being one that was on foot at the moment in time in which harm occurred.
How is this relevant to the
It's not
proceeding?
relevant.
We submit, Your Honor, that this particular relationship needs to be held in comparison to that of occupier and occupant, and that at this point in time, an employer-employee relationship did not exist. That in mind, Your Honors, I would like to conclude briefly by drawing attention to the significantly different relationships that existed in this case, comparing those of a transient and what was not employer-employee at that moment relationship between Ballers and Christopher Wallace, and what was a clear and onerous relationship that existed between Hatsis Global and Christopher Wallace at that moment. Other than that, Your Honors, I would once again suggest that reasonable foreseeability favors the appellant in this case in regards to the wide range of material facts that I have drawn before the court. That established, we suggest that liability and therefore apportionment should be reconsidered by the court in regards to these challenges to, with respect, Justice Carlson's finding at first instance. I will leave it to my junior to discuss the issues of the calculus of negligence and causation, and may it please the court, and if there are no further questions.
Just on apportionment, what would you put that?
We would submit that it should fall 90% on the respondent, Hatsis Global, and 10% on Ballers.
Thank you, counsel.
Thank you, Your Honors.
If it pleases the court, I begin my submission. Your Honours, I'd like to begin on a note which my senior counsel touched on and which Your Honours are obviously interested in. That is the import of the 22-year-old wall in this case. Your Honours, we submit that this wall presented a grave risk to human life long before our client was employed to attach a basketball hoop. The crucial point here is that this pre-existing risk at the breach stage of analysis goes towards establishing a higher liability. To put it in simple terms, liability was, when it comes to the question of apportionment, somewhat established before this accident even happened.
On what facts do you rely upon to say that Hatsis should have been aware of the problems of the wall outside of the social media speculation?
Your Honour, even before looking at the question of awareness, we contend that on an evidentiary basis that the wall presented a risk. And I'd like to quote from the facts at this point. In or around 1990, Hatsis Global engaged foundation layers to construct a dividing brick wall as part of its vision to provide an outdoor basketball court and a general outdoor recreational area for its students. The construction of this wall was completed in or around 1991. However, and this is the crucial part, due to falling enrolment numbers, the construction of the basketball court was put on hold. On its proper construction, this is really no wall at all. As alluded to by my senior counsel, this is a work site. And the facts speak for themselves. We have a 22-year-old work site sitting decrepit and unused at the side of a basketball court. Speaking to the issue of awareness, we contend that the posts on social media, as spoken to by my senior counsel, go towards showing actual or at least constructive knowledge, and the reason for this is simple. For students to have taken to social media, a forum where you only go if you have a legitimate worry about something and you would like to discuss it with other people, meant that the students had some sort of reason and impetus for going to that forum in the first place. So we propose that even if it weren't visible on the wall, that these students must have had some reason for thinking that it was dangerous, such as they'd leaned against the wall and it had swayed. Moving back to our affirmative material, I'd like to just give a brief overview of the submissions I'll make today. I will be taking off from where my senior counsel left you, that is, starting at 2.2 and 2.3 and speaking to the issue of breach, and then moving to the crucial issue of causation, that is our third submission, and speaking to how the breaches committed by Karantzis Global were more connected to the material harm that occurred in this instance. Moving straight to our submission at 2.2, we submit that under the calculus of negligence, and I've answered this question somewhat already in the answer I just gave, I hope, that it is highly relevant that actions committed by the respondent in this case had created a risk outside of that risk which happened to materialise in this case. In simple terms, that we need to consider Karantzis Global's actions in their globality, not just the specific instance, not just the specific facts.
Counsel, what actions are you talking about?
Here I'm talking about the non-feasance represented by not taking any action to maintain the wall for 22 years. Now, I've already presented the reasons we believe that the wall was on an evidentiary basis a risk.
Something on these websites.
With regard...
Is that all you're relying on? On social media?
It is indeed, Your Honour. We wouldn't completely disregard the import of social media in this instance. We'd say that
it's not important enough to report it verbally to the officials of the respondent. It's important enough to just simply place it on this social media outlet.
While we recognise the yardstick Your Honour is drawing, in fact, we'd say that it exists in a slightly different way in the university context. We'd say that it's not a question of importance. We'd say it's perhaps a question of our modern times and a question of the relationship that students have with each other as opposed to their university staff. We propose that it's perfectly reasonable in the day and age that we live in that students would report these problems to themselves. On top of this...
And not to the authorities in control.
Sorry, Your Honour.
And not to the authorities in control.
While we concede that this is, of course, a breach, some sort of breach on the student's part...
There's a concern about foreseeability here, isn't there?
There is, of course, a question of foreseeability. We'd say that this goes toward establishing negligence on behalf of the students, though, and not at all on behalf of the parties in the room today, that is, Karantzis Global. We'd say that the educational institution took whatever measures... let me rephrase, Your Honour. With regard to social media, we say that...
I mean, it's all good and well that these reports are made on social media, but if Karantzis Global, the respondent here, is not notified about it, doesn't know a thing about it, well, how is it foreseeable on their part that there's an issue with the wall?
And on the facts, you can't even say that the wall's not complete, can you?
Counsel, I think that draws a difference between non-feasance and misfeasance in this case, and obviously you're saying that Karantzis is potentially liable for non-feasance, but I think you need to probably prove misfeasance, and that's what His Honour Karantzis is alluding to.
Okay, thank you for the clarification. In this instance, we believe that it goes beyond non-feasance to misfeasance, malfeasance, on the basis that we're talking about an occupier who is elected to occupy a specific building. Now, whether or not the wall was there, in fact, we know on the facts that the wall was not there to begin with. So we characterise the initial act of choosing to construct that wall as an affirmative act and therefore going towards malfeasance. Now, even in a general sense, we submit that occupiers need to be always wary of the buildings and structures that they have elected to either occupy or to build. But in this instance, it goes a step further. It's a wall that they've not only elected to build, but it's a wall they've elected not to finish to build. Considering these circumstances in their globality, and I'll wrap up my submission under 2.2 there, we'd submit that this was an affirmative act, that the wall in and of itself presented a risk long before this accident materialised, and that under a proper calculus of negligence, this would be taken into account at the apportionment stage.
When you say risk, what type of risk? An obvious risk?
We do believe that a wall in and of itself presents a very obvious risk. We believe that, thank you timekeeper, that
akin to a trap?
There's no.
I don't know that we'd go so far as saying that there was an entrapment in this case. We'd say that a wall in and of itself presents the exact same risk that actually materialised in this case.
Well, if that's this case, wouldn't your representative, Christopher, have seen that if it was that obvious?
The factual distinction we've drawn on this point is to concede that the risk was not in fact visible on the outer appearance of the wall because neither party noticed it. The deduction we've drawn from that, the deduction we've drawn from the fact that the students knew it was dodgy, that there must have been some sort of physical give or other giveaway that people have been able to notice. With an eye to the time, I'm going to move to our third submission, that is under the heading of causation. And I'd like to just briefly remind the court of the words of Justices Gibbs, Mason, Wilson, Brennan and Dean in Podrebursek. That is, the making of apportionment involves a comparison of culpability, and here they've clarified, culpability is the degree of departure from the standard of care of the reasonable man and of the relative importance of the acts of the parties in causing the damage. The import here is that at apportionment, the court should be, at least on the outward appearance of those words, considering both causation and breach. So in simple terms, we contend that the breach of the respondent possesses the strongest causal nexus in this case to the harm that eventually occurred. And I particularly emphasise our submissions under causation, noting that our learned colleagues have made no submissions under causation, but invite them to speak to this point, give its importance in the calculation of apportionment.
Counsel, on the issue of apportionment, your own risk assessment was almost non-existent, because when the response was, I know nothing, I've only been here for 3 months, if the employer's representative had gone and spoken to a director and made further inquiries, you would have known more about the state of the wall, its history, if there was problems with it. And when you start comparing relative responsibilities and culpability, I would have thought that when you've got a your risk assessment was almost non-existent. It was very poorly conducted.
Well, I'd like to answer that question with a small concession, but then to tie it to a case, that of Grima and RFI. And I'll come back to that concession when I've just briefly outlined the material facts of this case. So in this case, a worker, thank you timekeeper, of the plaintiff was injured while unloading goods from a truck which had been unloaded by the defendant. The trial judge, the plaintiff alleged that the defendant had incorrectly loaded the truck, whereas the defendant argued that the plaintiff had failed to teach their employees how to properly assess the risk presented by the incorrectly laden truck. Now, the trial judge accepted both breaches and apportioned liability and damages at 50%. However, on appeal to the New South Wales Court of Appeal, the court re-apportioned liability so that the defendant, the party who had loaded the truck in the first place, was 75% responsible. And here they drew significant attention to the act of setting up a dangerous system to begin with, that is loading the truck, as opposed to the act of failing to identify a risk, that is failing to teach their employees how to get out of the truck and to look at the load and to determine whether or not they should seek to take the load off the truck. And we submit that this case is on all fours. The question Your Honour has asked goes to what should our client have been doing and how causally connected to that was the harm that eventuated. We say that whatever concession is made in this respect, the breach of the respondent has gone directly toward creating the risk in the first place. That is, erecting a wall, leaving it for 22 years, and then and otherwise commissioning the basketball hoop.
Counsel, but for the actual erection of this basketball ring on that wall, this probably would never happen though. What do you say to that?
Well, we have a two-prong answer to that. First of all, we remind Your Honours respectfully of the import of analysis at the breach stage. That is, the relevance that harm could have occurred in otherwise. And just briefly, with a view to the time, I'd like to ask for a small extension.
That's fine.
Thank you, Your Honour. But on top of that, we'd say that, yes, the harm could have occurred and would have occurred at some stage in the future. It wasn't the addition of a basketball hoop to the wall that led to this harm occurring. It was the addition of a basketball hoop that led this harm to occurring at this specific moment in time. A wall doesn't simply crumble, a sturdy wall, I should say, doesn't simply crumble via the addition of a basketball hoop. If the basketball hoop hadn't been added at this time, the wall would, we submit, definitely have crumbled in the near future.
There's no facts of that. There's nothing on the facts to indicate that.
Your Honour, with respect, the only answer I can give to that is to repeat our evidentiary analysis of the facts and to repeat our submission that the wall was indeed a liability for 22 years. And I said wall, but we submit once again that it was really just a glorified worksite. To finish up, Your Honour, I'd like to fly through our submission at 3.2. That is, that there is more social utility in holding occupiers liable than employers. I think it suffices here to say that occupiers' liability is strict for a reason, that the party in question failed to take any of the measures which an ordinary occupier would normally do, namely not having an unfinished worksite on their premises. We submit that this is a matter of justice, and it is occupiers who elect to occupy premises and who reap the commercial advantage therein. That is, it's a matter of justice that occupiers be held accountable, but it's also a matter of practicality. As we've already sought to outline, it is occupiers in the far superior position when it comes to conducting these routine checks and making sure these sort of things don't exist. So on that note, and if there are no further questions, I'll finish my submission there.
Thank you, Counsel.
Thank you.
If it please the court. This is a case about Mr. Wallace, the plaintiff at the first instance, who has suffered considerable damage and harm as a result of the admitted concurrent liability as between the parties here today. The proceeding we are here today to decide is the allocation of that liability between the parties. We would submit that a more appropriate allocation would be 80% towards the applicant and 20% towards the respondent. If before passing to my written submissions, I would like to clear up several of the mischaracterisations by our learned friends here. First of all, as the evidentiary basis of the condition of the wall, there were several statements made. One, that it was a grave risk to human life, pre-existing any construction being completed on the wall. There is nothing within the evidence that we have available in front of us that there was any issue with the wall before the installation of the basketball hoop. There is no evidence to say that the reason that the wall fell was because of the work that was completed by the applicants, or if there was a pre-existing condition with the wall, or that it was the weight of an individual hanging from it. There is nothing to any of those effects.
Counsel, what's your view on the social media angle that the applicant has raised?
The social media,
If I may, with respect, Your Honour, leave that for my co-counsel to address.
No problems.
Thank you, Your Honour. Further, there was allegations that there was actual knowledge. There is the potential of, and my co-counsel will elaborate, some knowledge, but there is certainly nothing within the evidence to say that the respondent knew that the wall had any pre-existing condition. And I would say that it's open on the evidence that there may have been due to the poor installation of the wall or a pre-existing issue with the wall, but that neither of these two things are overly relevant.
Why would you say that there's something pre-existing or on these facts?
On
Is
these
there
facts,
something
given the nature of the wall, and it was constructed correctly 22 years prior, there's nothing to indicate that there was a pre-existing condition. In either case, there ought to have been a structural engineer's report after the completion of the installation to assess whether the wall was indeed safe or not.
What do you say about the appellant's submission that this wall was not complete?
Well, it's a wall. It was clearly completed. The notion of it being a construction site is ridiculous because it was a completed wall that had sat there for 22 years and was open to the public. It's a wall. It wasn't requiring any further brickwork. All that was done was the installation of a basketball hoop upon it. So it was a completed wall, a completed fixture.
Counsel, John Snow's involvement in this matter is crucial, isn't it?
John Snow's involvement is relevant. It is probably not a crucial. I would speak here, and it's further on in my submissions, but I'll come to it now.
You sure he wasn't misleading?
I wouldn't characterise John's statements as misleading, simply ignorant. He was not aware of any issues, he wasn't aware that there was any problems, and he freely acknowledged his ignorance.
He's a representative of your client. The onus is upon him, isn't it? To furnish what the reasonable man would have in his exact circumstances. Did he act reasonably here?
I believe he did act reasonably.
In stating, I know nothing, I've only been here for 3 months.
I would submit that he did act reasonably because he gave his honest opinion. He did know nothing and he had only been there for 3 months. May I speak to the more broad issue of what a reasonable person in John Snow's position would do? What, if we look at the relevant duties here? If we come back to just very basic level here, John Snow has been charged with the installation of a basketball hoop and a basketball court. John Snow has then engaged a professional, somebody who knows what they're doing, has better knowledge of the situation than John Snow. He is not somebody who is an expert in these matters, so he has employed an expert, the applicant. The applicant should then have gone through the correct process, and the burden ought be on them to ensure that the work that is completed on the site that it is done safely. If it was not going to be done safely, they should have brought that back to John Snow.
Counsel, let me put the hypothetical. If John Snow was a director of the respondent, and there's 4 or 5 directors, so he doesn't know all issues surrounding the school or the education department, do you think that there'd be the same responsibility? Would that answer suffice?
I believe it would. I would submit that once one engages, if one is not competent in assessing the risk, one engages an expert who is competent in assessing the risk. There is nothing to say that the institutional knowledge of Hazmat Global had any bearing on this wall being structurally sound. In fact, there's nothing to say that it wasn't structurally sound at the time that the applicant arrived at site.
But if he was a director, he's got to make all reasonable inquiries to ensure that whatever he represents is accurate.
Most certainly, and John Snow ought to have made more representations, and this is why we would say that the respondent is partially liable, and we would say that the lack of John Snow making further inquiry and the lack of John Snow insisting upon a structural engineer's report does speak to the respondent's liability, which we would say is a fair assessment at 20%. If I may speak to the applicant's first submission, that there is a non-delegatable occupier's duty. An occupier's duty is not a non-delegatable one, and I would move to the case of Shell Harbour City Council and Rigby, New South Wales. In this, it was demonstrated that you can have concurrent occupiers and concurrent occupiers liability. If it is capable of being concurrent, it is capable of being delegated. But again, I would speak to the occupier's liability not being fully delegated, but being shared as between the parties. There is a far greater duty that we have here that the applicant held and owed to Mr. Wallace, and that is the duty of an employer to an employee, both at statute, as we have in Section 8 of the of the Workers' Compensation Act, building on Section 5.1. And in Section 8, if I may briefly quote the statutes, Section 8.2, where it, if I start part way through, it says, an injury to a worker shall be deemed to arise out of the course of their employment if the injury occurs while the worker on any day on which he has attended at his place of employment pursuant to his contract of employment, and then it has a little I, is present at his place of employment. That clearly demonstrates that this falls within an employer-employee relationship. This is where Mr. Wallace, having completed his day's work, has then engaged in a testing activity of the basketball court and has played a game of ball. He certainly has gone well and beyond his duty as an employee, but it is the applicant's responsibility to ensure that their employees act as they should, not the respondents.
Are you referring to the Workers' Compensation Act 1958 in this regard? Section 8.
Yes, I believe I am.
I would have thought the Accident Compensation Act 1985 is the relevant law here.
My apologies, yes. I did have. The provisions held within that Act are sufficiently similar. I do apologise, I do not have a copy of that available to me now.
You would be referring to Section 82 of the Accident Compensation Act 1985.
I thank you, yes, that would be correct.
Anyway, proceed.
Further, this duty of an employer to an employee is not a delegatable duty. But in this instance, there would be no one to delegate it to, as it is the responsibility of the employer to ensure and this is from the case of O'Connor and the Commission for Government Transportation, if I may dispense with full citations, the proper and adequate means of carrying out his work without unnecessary risk by warning him of unusual or unexpected risk and by instructing him in the performance of his work where instructions might reasonably thought to secure him from danger or injury.
Counsel, has your client done that?
Our client?
Yes.
Our client, as the respondent, did not owe said duty. It was the employer's responsibility.
Really? You're the occupier?
Yes.
It's your premises?
Yes.
You don't owe any duties at all?
Most certainly we do. We owe a duty as the occupier. We don't owe a duty as an employer. And
exactly.
That duty I was speaking of was the employer's one. But most certainly Your Honour is quite correct. We do owe a duty as an occupier.
All right, proceed.
We would submit that the applicant did not provide safe working systems and safe working instructions to Mr. Wallace to ensure that he was not injured in the course of his employment. This accident clearly falls within his employment, whilst it's not an activity that would have necessarily been condoned.
Does it there? If I may interrupt, does it there, counsel? Are you sure this accident was in the course of work?
It was in the course of, it falls within that section that Your Honour...
He's not on a frolic of his own?
As to being on a frolic of his own, this is the Comcare case, of course, versus PVYW, where there was an employee who was engaged in a certain extracurricular activity whilst they were in the domain of their workplace. I would say that the difference here, we would submit that in the case of Comcare, that extracurricular activity was completed well after work, not a short space afterwards, and also was entirely distinct. Whereas this, we have the the creation of the basketballs, the construction of the basketball courts, and then the testing of the basketball courts. It's not unreasonable that one may test out what one has finished.
But this test was after the game had ceased. Christopher was showcasing his slam dunking prowess.
Most certainly.
And that's in the course of work?
And that would speak to a potential contributory negligence claim
Exactly.
to the plaintiff who is not a party to this proceedings.
Strictly, it's not relevant to this issue in any event. Please
Most
proceed.
certainly. If I may speak to the JSA and the permit that was issued, just in relation to the timings of these matters. The risk assessment and the permit, to work, were all completed by the applicant. And the applicant spoke of deficiencies within this process. But all of these processes were on the applicant's side. That permit that was issued, and I believe the first counsel for the applicant spoke of the timing of these various natures, of the timing of each of these activities, and that there was the risk assessment completed prior to the specific placement of the hoop being decided. The respondent submits that it was the applicant's burden to complete a proper risk assessment and to ensure that the wall was safe before proceeding, and that they should not have issued that permit to work before having completed that process.
Well, when the wall was complete and the hoop was installed, should there have been signed off by someone?
I'm sorry, Your Honour.
When the wall was complete with the hoop installed, should there have been signed off by an engineer perhaps?
Most certainly. We would submit that the applicant ought have got a structural engineer to ensure that the wall was safe. And my learned co-counsel will elaborate on that point. If I may speak to the case that was brought up in the first instance by the applicant, Podvinsek and Australian Iron and Steel Limited. They're quite correct in determining that the two salient features of this are the degree of departure from the standard of care of a reasonable man and of the relative importance of the acts of the parties. To speak broadly, the departure of a standard of care, we have on the one hand a tertiary education provider who has an agent, an employee, John Snow. They have very little knowledge of the matter. We have on the other side a professional company in the industry of installing basketball courts and basketball hoops. There is a clear gap in knowledge, and there is a clear gap in the levels of ability to inquire as to this wall. We then look at the relative importance of the acts. Whilst it is true that John Snow and Hazmat Global ought to have insisted on a structural engineer's report and ought to have provided better information, the applicants are the ones that ought to have done a proper risk assessment. They ought to have checked the structural integrity of the wall before entering into the activity of installation, and when they completed their job, ought to have ensured that it was safe for these to be used.
Counsel, my issue with this is that this is obviously not a small construction site or job. It's been funded by the government, so we're talking a fairly important project here. And you're only putting your client's responsibility apportionment at 20%, but your client, one only providing, an employee's only been there for 3 months, not providing them with any information. I feel like they just haven't gone far enough. And I appreciate your discharging your duty to the appellant, but at 20%, what do you say to that though?
Again, I would speak to the relative expertise that both of the parties had, and the expertise of John Snow. He acknowledged he didn't know, so he engaged an expert. That is what one does if one doesn't know. And there's nothing to say that there was anything further that Hazmat Global could have done. As to whether this was a big job, I'm not necessarily certain that's a fair characterisation. It is, whilst it was funded by the government, it looks as if from the dates it was completed over a period of 2 to 3 days at maximum. So it was not a large construction job by any stretch of the imagination. So it doesn't seem unreasonable that in the absence of knowledge, they would consult an expert. My time is concluded if there are no further questions.
Thank you, Counsel.
Thank you, Your Honour.
Your Honours, before I begin my submission, I would like to address a point that came up in the statement of the applicant in this case regarding social media. First, social media, and particularly Facebook, is quite a decentralised space. There can be many groups devoted to one topic, and also there is a likelihood that a group such as a stalker space group could be closed or restricted in its viewing. Hence, it is quite possible that Jon Snow and Karantzis in general did not know about the comments that were being made in relation to the wall on this group.
Counsel, Jon Snow, though, is how the position is as described. Duties varies, but focuses on managing online publications and gauging student sentiment. I would have thought the online space is right on point in this regard.
Yes. First, I would like to say an online publication is not the same as a Facebook group. Second of all, a stalker space group is more than likely being set up by students outside of the unit or outside of Karantzis's administration or control. And as I said before, such groups can frequently be closed or have restricted viewing. And it's quite possible that Mr. Snow did not have access to this group.
That's not on the facts, though.
No, that is not in the facts. This is just setting up an alternative. We don't know. That's the entire thing here. We don't know who had access to what knowledge and when. Second of all, in relation to the comments being made on the stalker space about the wall being dodgy, we do not know in what aspect the students were discussing the dodginess of this wall. We do not know that they were referring to the structural integrity of the wall. It is quite possible that they could be referring to other...
Counsel, that's fine. However, what steps did your client take in inspecting the wall over the last 20 odd years?
We do not have in the facts
Exactly.
access to this. This is just to state that...
On the facts, nothing has been taken.
Yeah, I would agree with that.
And that's the concern, isn't it?
It is a concern, and we have admitted that we do have some contribution in this case at 20%. This is one of the factors that has led us to this conclusion.
And your representative, Mr. Snow, has admitted himself that he's only been working there for 3 months. I know nothing. So what steps did he take after giving that statement in regards to the safety of the wall?
Again, on the facts, we don't know if any...
Well, it's implicit that nothing occurred.
My concern is that if Jon Snow had knowledge or constructive knowledge of these complaints on the website, is his statement that I know nothing, I've only been here for 3 months, misleading?
I would say that it goes back to we cannot establish on these facts whether Jon Snow had knowledge or constructive knowledge.
Well, the question after that is, should he have had that? Given
yes, we can see that he should have, and that that lack of constructive knowledge on behalf of Mr. Snow is where we are admitting liability, admitting that we should be paying a proportion of the...
In terms of culpability of the two parties, do you say that the appellant, in not conducting, or what doesn't appear to be a proper risk assessment, is it's a high level of culpability than your client saying to the appellant's representative that I know nothing, I've only been here for 3 months, in circumstances we should have had actual or constructive knowledge of the complaints about the wall? What do you say about the respective culpabilities?
Yep. In relation to the respective culpabilities, I will go to my submission, which deals with this. So the respondent in this case is not, and was not at the time, an expert in ascertaining the structural integrity of walls. The respondents, to the extent possible in law, delegated their duty of care to the applicant. The onus then falls on the applicant when Mr. Snow has said he has no knowledge to obtain that knowledge. How they obtain that is up to them, whether they go through structural engineering, whether they try and find somebody else that works for HATSIS that may have had that knowledge, but the onus is on them, the applicant, not on us, because we were not in the position, and we are not in the position to know about the structural integrity of this wall. I would also like to refer to a document that is produced by the Building Commission of Victoria relating to the construction of basketball hoops. And this document states clearly that one should engage a structural engineer before constructing a hoop on a wall. It also explicitly states the reasons for this being that walls are not designed to take the forces that are involved in having a basketball hoop attached to them, particularly if people are using them for slam dunking.
Counsel, it's a double-edged sword because that document can also be used against your client in this case, just as strongly as it can be used against the applicant. Because you are the occupier and you are the ones wanting to construct this basketball court and ring and so forth. So why can't they use that exact same document against you?
I would submit that this again goes to who should have had knowledge. They have specialist knowledge of the construction of basketball courts. We do not.
And they should have got sign-off, is that what you're saying? To take it one step further? They should have got sign-off on the actual construction when it was complete?
Well, a signed permit, under the agreed effects, a signed permit to commence work was issued.
I know, but what about when the work's complete? Should they have got an engineer to inspect it to ensure it was properly completed?
Absolutely, Boylston campus should have employed an engineer. At the time of completion, to ensure that it was structurally sound once the basketball hoop was in place. Under the test established in Wyongshire Council and Shirt, 1980, 144 CLR at 40, can I please dispense with full citation?
That's fine.
And under a stricter alternative test proposed in New South Wales and Fay, it must be concluded that the applicant had greater knowledge as to the foreseeability of the risk. The respondent was not in a position to appreciate the significance of any risk present either. Under the much discussed test in Podrobestic and Australian Iron and Steel, the respondent is both more culpable and has committed acts of relatively greater importance in causing Mr. Wallace's injuries. The applicant was or ought to have been in the position to appreciate the presence of a foreseeable risk and to appreciate the significance of that risk. The respondent was not in such a position and could not be expected to have that knowledge. If your honours have no further questions, that completes my, sorry. I will now turn to the question of discretion. The burden required for this appeal against the judge's discretionary findings is that contained within the House and the King, was recently found by the New South Wales Court of Appeal that this ruling applies to apportionment. The burden is thus. It is not enough that the judges composing the appellate court, that if they'd been in the position of the primary judge, but they would have taken a different course. It must appear that some error has been made in exercising the discretion.
And what do you say is the error here?
The burden is also met if the judgment is upon the facts unreasonable or plainly unjust. It is submitted that Justice Carlson made such an error by finding that both the defendants owed a duty to the plaintiff and effectively breached that duty. As this statement implies, the duties are the same when in fact they are different.
What is the error here?
The error is that there were two duties of care. However, Justice Carlson, the one that we owed as an occupier, and the respondent concedes that we owe as an occupier, and the duty of care that exists between an employee and an employer. As my co-counsel has established, the duty between employee and employer is not delegable. It has been considered in law to be a greater duty than that held by an occupier, whereas the duty that we held was delegable and we would argue had been delegated between both parties. Both parties were concurrently in occupation of the space at the time the incident occurred.
How does that affect apportionment between the parties?
We would argue that the judge has placed significantly more of the apportionment on the respondent than is reasonable and just based on the facts of the case. Apportionment must turn on the facts, and as we have established here, the respondent had both a higher duty of care and they had breached it in a way that, using the test in Podrebestic and Australian Iron and Steel, was greater than that of the respondents. If you have no further questions, that concludes my submissions.
Thank you,
Counsel.
Thank you.
Rebuttal. Counsel, what I'm particularly concerned about is when we're looking at respective culpabilities of the two parties, we're trying to, the plaintiff conducted a risk assessment, which seems to be pretty poor, to say the least. And on the other hand, the respondent has made a representation saying, I know nothing, in circumstances where it should have been actual constructive knowledge of complaints about the wall on social media. When you balance the two, why should Why isn't 60/40 appropriate?
Your Honor, if I may reply to that particular question with two separate submissions. Firstly, again referring to the case of Grima, the court in that particular decision made a distinction between two different types of acts. That is, affirmative acts, such as in this case, having the wall there, and tangential acts. That is, for example, the action on the appellant's behalf of not asking enough questions or doing enough investigation. That separation was particularly relevant in reapportioning from 50-50 to 75-25. Furthermore, Your Honor, speaking to the separate point in regards to John Snow as a representative, Your Honors have correctly identified this point in your questions with our learned friends in regard to there were two different things that could have been done here. Either someone else could have been the liaison, someone with the appropriate amount of information, or that he needed to make himself more aware. We emphasize at this point that although our submission is that actual knowledge existed, constructive knowledge is sufficient in this case to determine this particular breach. So on that matter, we rely on the fact that John Snow was a representative that should have known.
But he wasn't a director of the company in question. And if he was a director, he couldn't hide behind the fact that he didn't know. He should have made all reasonable inquiries to satisfy himself as to the state or condition of the wall.
That's correct, Your Honor. We rely, in this particular circumstances, on the particular role of John Snow pointing to the university's intention and capacity to understand the particular risks in relation to the issue of stalker space. If I may, however, Your Honors, I would like to make a few brief submissions on some of the points covered by our learned friends. In regards to the issues of occupiers' liability, it has been acknowledged that this, of course, exists. The dispute here is whether or not it was delegated. Your Honors, we rely once again on our submission that this wasn't the case, this wasn't the particular case in this case. That while, of course, occupiers can in many ways delegate out duty, if that didn't happen, that duty was never removed from the occupier. It rested with HATSIS in these particular circumstances. Further, Your Honor, I would like to speak for a moment in time in regards to the independent frolic, a point raised by the senior counsel of our learned friends. Your Honors are right to question at length the issue of employer-employee in these particular circumstances. And I'd like for a moment to draw attention to the material facts. Specifically in this case, that Christopher Wallace had finished work early, 2 hours before what was expected by himself or ballers, and decided to play a game, itself synonymous with being on a frolic. Lastly on that matter, he was engaging in a celebration that is a personal and spontaneous expression of his emotion. This, Your Honor, cannot be seen as incidental to the course of employment, either on common law or on statute. We draw an analogy to the case of Deaton's and Flew, in which a barmaid throwing a glass in the face of a patron was found to not be acting in the course of employment. The object of her employment was engaging with patrons. However, this was seen as not being incidental.
Counsel, but why would have, in the first instance, your client accepted liability for the plaintiff's injuries if you're alleging that it was an independent frolic?
Your Honor,
I just don't see the relevance in this current proceeding.
In this particular submission, in that regard, Your Honor, with an eye to the time, I might move on if it's not relevant to Your Honors.
So,
finally, Your Honor, I draw attention to one of the extraneous materials brought in by our learned friends in relation to the WorkSafe guidelines. This document about basketball rings from May 2014, with respect to our learned friends, is outside the scope of this court's inquiries. This particular document was raised after the time in question in which this incident took place. Just briefly, Your Honors, in the case of Rowe and Minister of Health, it was emphasized once again that a court must have foresight when considering the particular circumstances, not hindsight. We submit that the fact that the wall not being maintained could be dangerous was well known at that point in time. As for basketball rings, we cannot speak to that particular issue because of this particular consideration of the court. Your Honors, noting that my time has concluded, if there are no further questions.
just one more for me. You both counsel for the applicant have made a fair few concessions today. Tell me why your client should only be 10% liable for that.
Your Honour, you are correct in asserting that we have made several concessions because fundamentally this was never an exercise of proving any one point or proving all of our points or relying on an argument that balanced itself out across each stage of the calculus. Instead, this was about holding a comparison to the respondent in this case. At each level, we feel we have established there was either a significantly different relationship or that there were significantly different magnitudes of breach committed. On that matter, Your Honor, I would rely heavily on our particular argument at causation, which we note has not been addressed at length by our learned friends. With that in mind, Your Honors, and may it please the Court.
I've got another question.
Yes, Your Honor.
When the work was completed by your client, or when the employer completed the work, should there been sign-off in terms of the standard of the work and if it was sound quality and safe?
Your Honor, do you refer to a sign-off on behalf of HATSIS that they were satisfied? Or?
No, sign-off in terms of the installation of the hoops. Surely there's got to be some sort of testing at some point.
Your Honor, we would submit that the relevant consideration here was the testing that occurred before the work completed, that in relation to the JSA and risk assessment, because the fundamental duty that has been asserted by the court would be that to employees if the court does find against us on that matter. Therefore, the relevant breach is that which our client failed to take into consideration at first instance.
Thank you, Counsel.
Thank you, Your Honors.
I want to thank the parties for appearing before us today, and the arguments were very well put together. The starting point is the High Court says in the apportionment cases, it's generally, because it involves a level of discretion and also subjective assessment, and different people can come to different conclusions, the High Court said that in very rare circumstances should you really alter a trial judge's finding. However, in this particular case, we find that it was remiss of the appellant and incumbent on the appellant's representative to ask further questions when conducting a risk assessment in light of the responses received from the respondent's representative. And also the appellant had a greater level of expertise and knowledge in the construction of basketball courts. So we're fined 80-20 in terms of apportionment, 80% to the employer, 20% to the respondent. The appellant's case on the evidence was a lot harder, a lot more difficult. There was insufficient facts to really assist the appellant on this appeal. There was a lot of speculation, innuendo. Notwithstanding the fact that we found for the respondent, and on the assessment of the Moot itself, it was a very closely run race, but we found for Melbourne Uni. So even though our judgment supports the respondent, we've scored it and all the assessments are here. And once again, I want to congratulate the parties. I think you did a really good job, and it's interesting. I hope you got a bit out of this, as we did, I think. Did we get anything out of it?
Yes.
Yeah.
Thank you, Counsel.
Thank you, Counsel.